Good afternoon everyone. My name's Andrew Clugston. I'm a partner in the Business Advisory Division of Pitch Partners here in Melbourne. And joining me today is Craig Whatman, a partner in our tax consulting team, specialising in indirect taxes, including GST, stamp duty, land tax. And the idea of these videos is really to give a concise update on current issues impacting the property industry, in particular in tax. And one of the key issues at the moment is the new 3% stamp duty increase for foreign investors and also land tax as well. So Craig, we might just start with stamp duty to begin with. Maybe if you can just give us a bit of an outline of what happens with an acquisition of a property by a foreign purchaser where the property is less than $960,000.
Sure, thanks Andrew. So there is a progressive scale of duty rates that apply for properties with a value up to $960,000. Once the value reaches $960,000, the flat rate of stamp duty applies at 5.5%. So for a foreign purchaser that acquires a property with a value up to $960,000, essentially what would happen is that the 3% surcharge would be added to the existing duty cost based on 3% of the purchase price.
Right, and so that's a full purchase price where there's no off-the-plan concessions or anything like that?
That's correct, yes. One of the issues that will increase the cost significantly is where there is an off-the-plan acquisition, the 3% will apply to the full purchase price rather than to the reduced off-the-plan value. So just to give you an idea of the type of increase that will give rise to, if you take an apartment, for example, that's purchased off the plan with a value of $500,000, if you apply the off-the-plan concession to that acquisition, normally you could reduce the stamp duty down to around $3,000, but the 3% surcharge will be applied to the full $500,000 purchase price, which will mean that the total duty will actually go from around $3,000 to around $17,000.
Okay, so it's certainly a significant increase. What about if we look at foreign developers acquiring property and just the way they structure that and how that might impact the new stamp duty? So if a client buys land, say, in a joint venture, 50% foreign owned, how will the stamp duty apply there?
Sure, so where you have a joint acquisition and there's two entities that will be joint owners of the land, and one of those entities is a foreign purchaser as defined in the legislation, then the way the surcharge would work is that the 3% would be imposed only on the interest that's acquired by the foreign purchaser. So if it's a 50-50 JV, for example, then the 3% would be applied to 50% of the value.
Right, and so what about if then it's acquired in a company and 50% of the shares in that company is owned by a foreign purchaser?
Yeah, so that will come down to whether the company is a foreign corporation as defined in the legislation. So there are quite complicated rules in the legislation to determine whether an Australian company, for example, is a foreign corporation, and that really depends on whether it's deemed to be controlled by a foreign individual, a foreign corporation or a foreign trust. Even in a 50-50 situation, 50% ownership, it's still possible that the rules could deem the company to be controlled by a foreign person, and that would mean that the 3% surcharge would apply to the full purchase price of the land acquired by that company.
Right, so now it becomes important, I guess, when clients are looking at acquiring property, just how they structure it can have a big impact on the stamp duty they pay. Yeah, okay. Now, we know that the new stamp duty will only apply to residential acquisitions or acquisitions where it's intended to be residential development. So what happens if a client buys a site and they're really not sure when they acquire it as to what they're going to do with the site?
Yes, that's going to be an interesting one, because the legislation at the moment says that it's only residential property that is caught by the 3% surcharge, and residential property is defined to include vacant land where the foreign purchaser has an intention to build residential premises on the land. So if a foreign purchaser were to acquire land without having an intention to build residential premises at that point, then under the legislation it won't be residential property, and therefore the surcharge wouldn't apply at that point. But if subsequent to that the foreign purchaser forms an intention to build residential premises on that land, then the law actually requires them to lodge a notice with the State Revenue Office of that intention, and the surcharge would then become applicable at that point.
Okay, so it sounds like it'll be difficult to avoid it. And what about Australian developers? How are they going to be impacted by this?
Yeah, where an Australian developer has some foreign ownership within their group structure, then it will be important for them to evaluate whether that might have an impact under the new rules. So the ownership rules do allow the State Revenue Office to look all the way through to the top of the ownership tree, and if there's some foreign ownership there and that is relevant to the acquisition of the particular interest in land, then that could mean that we do have an acquisition by a foreign purchaser. So we understand that the government's currently preparing some guidelines which will determine how they apply those sorts of tests to Australian developers with some foreign ownership in their structure, and we'll need to wait and see how those guidelines are to apply, but it's going to become quite an interesting position for some of the Australian developers.
Right, okay. And just finally on stamp duty then, I've been getting this question quite a bit from some of my clients who've signed a contract, but the contract's not yet unconditional, so they've signed it subject to FIRB, and they suspect that probably the FIRB approval won't come through until after 1 July. What does that mean for them?
So based on the legislation as it exists at the moment, and we need to bear in mind that it's still before Parliament, so we don't have a legislation that's in force as yet, but based on the legislation that's before Parliament at the moment, any contract that's signed prior to the 1st of July this year will be grandfathered whether or not it's conditional or unconditional. So even if you have a conditional contract, as long as that contract is signed prior to the 1st of July, our understanding is that that would be protected and the surcharge wouldn't be applicable.
Okay, that's good to know. All right, well, moving on to the land tax then, do you want to just give us a little bit of an overview as to what's happened to land tax with foreign owners?
Sure, so the land tax is intended to apply to absentee owners, and it will be a surcharge over and above the existing land tax rates of an extra 0.5%. And the way that will apply is if you are deemed to have an absentee owner or one absentee owner out of several owners that are the owners of the land, then that's additional 0.5% surcharge would be applicable to each land tax assessment.
Right, okay, so in a situation where land's held in a trust, how's the SRO going to know that that's actually foreign owned?
Yeah, that's an interesting one. I think the main way that the SRO would catch up with that is through they have quite significant data matching capability now with other government agencies, and a particular example of that which would be relevant in this situation will be the data matching that they do with ASIC. ASIC provide them with the data of various entities, and the SRO use that for their for purposes. And so in an example where you've got a corporate trustee and that trustee has shareholders that are non-residents of Australia, then the SRO may well get that data from ASIC and use that to determine whether you've got a foreign trust for these purposes.
Right, okay. Well, obviously this stamp duty and the land tax, they're state-based tax, so we're only talking about property in Victoria. What about the other states? Have they indicated that they're going to be following in Victoria's lead?
No, so far none of the states have indicated that they will be imposing the same surcharges or similar surcharges to Victoria. In fact, the Queensland government came out pretty quickly and said that they wouldn't be following in Victoria's footsteps. We haven't seen any announcements from the other states and territories as yet, so we'll just have to wait to see what happens there.
All right, we'll keep a watch out for that. Well, thanks for your time today, Craig. It was certainly useful to get these questions all out on the table at once, and hopefully it's provided a bit of information to our clients.